How to use prior art in patent search. The idea of prior art plays a crucial role in the patent prosecution process, as it ascertains the novelty and non-obviousness of the invention stated within a patent application. Throughout this process, a patent examiner undertakes the task of meticulously scouring for prior art. This looks for any information that was widely known before the patent application was filed. This includes a broad range of printed materials. That has books, papers, literary works, patents, and other publicly accessible knowledge. In the event that prior art is discovered, the patent application may be rejected. This closely resembles or replicates the invention that is claimed in the patent application. The applicant may then be given the chance to amend the claims or produce evidence. This highlights the invention maintains its originality and non-obviousness, despite the existence of prior art. To put it briefly, the Patent Office assesses whether the innovation makes a novel, beneficial, and non-obvious contribution by consulting the body of previous IP research in the process. Worth noting is the global scope of the previous art search. This extends beyond the borders of the nation where the patent application is submitted. By incorporating prior art into the patent application process, it is made sure that only novel and inventive inventions are granted patents. Additionally, this promotes innovation and lowers the need for wide patents. Applying prior work shows how crucial it is to encourage creation, as it upholds the requirements of novelty and non-obviousness, while preventing the granting of patents that would unnecessarily restrict innovation and competition.